All right. Well, thank you for all coming to our program today. We are honored to have the Honorable Justice Stanley Feldman with us today from Tucson. It's a pleasure. And Sanda Clark is one of the reasons that he's here. She recommended him highly. I have heard nothing but positive commentary about the justice, a fine man. I could spend a long time introducing him, but I'm just going to say a few things about him, and then he can take it from there. The justice was born in New York City, and his father was in the grocery business. His mother modeled fur coats, right? And at the age of 5, when Stanley was 5 years old, his family moved to Tucson because of his mother's health. He was a good student, curious. He played sports. He didn't watch TV because there really wasn't much TV back then. But he got a degree in history from the University of Arizona. And then he went to law school there, where he finished first in his class in 1956. So that's an honor. He founded his firm in 1968 after some years of practicing law. He then served on the Arizona Supreme Court from 1982 to 2002, correct?
Yep.
He was the Chief Justice for 5 of those years. He's received many awards consisting of civil rights, humanitarianism, and others. He's been the president of the PEMA and the Arizona Bar Associations. He's now practicing still. Arbitration, lecturing, consulting. He spends time at the University of Arizona basketball games. He's been an adjunct professor at the University of Arizona, and there's even a courtroom named after him there on campus. What an honor. Now, the last thing I will say is this week, March 9th, Stanley Justice Feldman turned 89 years old, and he's still going strong. So he's going to speak with us now, and please have questions ready for him. He wants to try to answer the questions that we have. So take it away, Justice Feldman.
Okay. Thank you for the nice introduction. I appreciate it. And I'm glad to be here. Thank you for asking me. I don't want to speak too long because I know you all have questions and I enjoy answering them as best I can. But let me start for just a few minutes with first a historical note, because the history of how we came to become a country and how the Constitution got written and the problems that existed at that time and are still with us is very important for an understanding of everything going on today. The Revolutionary War was fought before the Constitution was written, and it was fought by a group of 13 sovereign states, the 13 colonies, almost all of which had different cultures, different origins, different economics. The southern colonies, for instance, were entirely rural almost, and existed by reason of slave labor to a large extent. The northern colonies were much more industrial, seafaring, and not nearly as dependent on slave labor. So that's how the war was fought. There was a Congress of representatives from all of those colonies, and the Congress had very little power. There was no executive branch, no president, no executive branch, no judicial branch, no courts, except for those that existed in each of the colonies. The Congress that had been come together had very little power. It could not lay taxes, for instance, and the purpose of the ability to raise money in order to fight a war was very limited. The Congress made assessments against the various colonies, and some paid and some didn't pay. Rhode Island, for instance, never paid. Connecticut paid once in a while. So that was the background. So when the war ended in the early 1780s, we had this group of colonies that had considered themselves almost as sovereign nations. And the effort was to write a constitution that would put them all together in one country. And they went along for 5 years, 6 years before that got accomplished. And in those 5 years, there was absolute chaos. There was no single system of money. Each colony had their own money. Some used British pounds, some used Spanish money. There were taxes and no taxes that were assessed by each of the colonies against the other colonies. And so then they finally got together, and in 1787, the Constitution was written and was put out to the states for ratification. There were three problems that existed then. They existed then, and I mention them now because we have never solved them. The first was slavery. The southern states had to rely and had relied to a great extent on slavery as a foundation of their economy. The northern states, as I said, not so much. So what were we going to do about slavery? The northern states, many in the northern states were opposed to it. Everybody in the southern states that was a delegate to the Constitutional Convention was strongly in support of it as what they saw a matter of necessity. So the Constitution was written and the word slavery was never used. It does not appear. But there were three things in the Constitution that were designed especially for slavery. There was one clause, for instance, the so-called Fugitive Slave Act, as it later became known, that provided that any person held for servitude in a particular state who had escaped to another state should be returned. No trial, no extradition, just return, given up and returned. There was a provision in the Constitution that provided or prohibited any state and Congress from passing any law for 20 years that had that would prohibit the quote importation of any persons. Well, what they were talking about is the slave trade. You don't import persons, you import goods, and slaves were goods. So they prohibited putting an end to the slave trade. And the third thing was the fight over big government versus small government. The small states and many of the other states were very much in favor of retaining their sovereign powers. So in the long run, the Constitution was written so as to give the new country, the Congress and the president, only certain powers. Those powers which were not given were not allowed to the federal government. All other powers were reserved to the states. And so really the thing that lasts with us to this day is that the federal government can do that which is permitted in the Constitution, and the state governments can do anything else and anything they want except what is prohibited in their state constitutions. So we're still trying to balance that. Then we had the fear of strong government, as I mentioned, which split powers completely between the executive branch and the legislative branch of the government. For instance, the power to declare war was given to Congress. The power to be commander-in-chief of the troops was given to the president. And how those two things were done was not specified. The founders of the Constitution were very bright in many, many ways and very well educated. And the one thing they knew was to draw the Constitution in very general terms, because to be too specific would provide for only the moment they were in, and they were trying to draw something that would last for decades or centuries. So a lot in the Constitution is not specific and has been spelled out over the years as a matter of historical content. But that problem is still with us today. There are a lot of things that need to be interpreted that go back to the war powers and the present problem. Could the president send troops to the Ukraine to fight the Russians? Well, he's commander-in-chief of the army, but the Congress has the power to declare war. And that's a problem that's been with us now. We've been in wars. Well, let's just go back to the turn of the 19th century, the Spanish-American War. We've been in wars one way or another since then. We were in the First World War, in the Second World War. Among those two wars were declared, but there was never a declared war in Vietnam, in Korea, in the war in the Philippines, the rebellion in the Philippines, the invasion of Haiti twice, the invasion of a South American country. All those were done on Congress simply permitting the president to deploy troops. So how far could that kind of question go in the present situation? We don't know. And I hope we don't find out. So the problem in interpreting the Constitution and its general provisions like due process of law, privileges and immunities of citizens and so forth, is the question is interpreting it to have meaning. I'll give you one more example that's with us to this very day, and that is the provision having to do with the question not just of war, but the question of elections. The Constitution gives the states the power to determine the representation or the naming of electors in the presidential elections. But it does not really decide how the states should elect those electors. That's left to the states. So in the last election, you had election slates of electors sent by the states, and then other slates of electors sent by various entities in the states. And how are these to be counted and by whom? So all those are problems yet to be solved. So let me stop there and let me ask you now for some questions. I think it's a good idea if I mention the amendments. The first 10 amendments were passed by the first Congress and sent out to the states for ratification. And what is seldom realized to this day is the first 10 amendments were intended to apply only to the states, only to the federal government, I mean, and not to the states. And then only beginning in about 1916 that the Supreme Court decided to apply those 10 amendments, which the First Amendment starts, Congress shall make no law. From starting in 1916, the Supreme Court started to decide that each of those amendments applied to the states as well as to the federal government. So the question always in all these unsolved, uninterpreted provisions of the Constitution, non-specific provisions, is simply this: how do you apply them to specific problems that exist at any particular time? And the last thing I'll say is, do not believe anybody who is appointed or to be appointed to the Supreme Court who says, I'm going to interpret the Constitution just as it is written. Because the problem is never what is written, it is what is not written. And that's the subject of almost every quarrel today. A lot of you may feel, for instance, that the provision that each state has 2 senators is unworkable and unfair, given the fact that California has 34 million people and 2 senators. And if you take Wyoming, Idaho, Montana, South Dakota, North Dakota, Delaware, and Alaska, all in one lump, they have probably a total of 10 million people, and they have 20 senators. So it's outweighed, but it's a really unworkable situation as we're going through now. But it's written that way. And there's no choice about it because that is specific. So everybody is willing to apply what is written, but the interpretation of what is written is always a big question. So I'll open it up for questions now.
Okay, let me ask you a question first before someone else jumps in.
Okay.
You look at the First Amendment, there are 5 parts to it, but the 3 that strike me as to what has been going on, and it's the freedom of it's press, speech, and assembly. Now, the press has been attacked for the last few years. And was it freedom of speech and assembly? How does that apply to the January 6th event in Washington, D.C., in your opinion?
Well, it applies to having a demonstration in the streets protesting what they thought was a stealing of the election. Yeah, that is protected by the Constitution. But the Constitution doesn't protect insurrection or interference in the acts of government, or storming the Capitol, or acts of violence. And so what happened on January 6th was clearly not protected by the First Amendment. It went way beyond what the First Amendment protects.
Well, thank you very much. And
let me interject one more thing. They just finished the first big trial of someone who was engaged in the storming up the steps of the Capitol and going after the policeman and carrying a pistol and yelling that he wanted Nancy Pelosi's head. That trial just finished last week, I think, or maybe this week. And jury was out 3 hours and convicted the guy of all 5 counts. So that's a very important result.
And I think that the First Amendment language is peaceful assembly.
Yeah.
I don't think that was peaceful assembly that day.
No.
So, Doug, did you have a question, please?
Well, I was going to ask the justice how he would interpret a well-regulated militia.
Well, the well-regulated militia referred to the state militias, which were very important in fighting the Revolutionary War. And the Constitution, when it says well-regulated, this is one of the interpretations. The militia is formed by the states, but is subject to regulation and control by Congress, can be called into federal duty. The Constitution is very specific about that. And as a result, there are regulations and standards promulgated by both state and federal government.
All right.
But you have to understand the history. A well-regulated militia and the existence of a militia was very important when you had no federal army, except the federal army as it existed before the Constitution was written and approved was simply more of a voluntary army, because the Congress had no power to conscript soldiers.
Well, the reason I asked the question is, as you may tell by my accent, I'm not native born, although a citizen. It seems to me that a well-regulated militia is not individual rights to carry any arm, including military arms, at will.
Oh, absolutely not. It refers to an organized group of armed men under state control and staying under state control until called into federal service.
It's a 27-word amendment. And those who want to use their guns only pay attention to the very last part.
Okay.
The right to keep and bear arms. And they think that maybe it's unlimited, but it's not.
Oh, you mean the Second Amendment?
The Second Amendment, the last part.
All right, now we're back to how the Revolutionary War was fought, largely through the militias of each state.
Mm-hmm.
And the country was at peril, both from the Native American tribes that had been hostile or whose land had been taken, and also from both French and British governments. especially the British government, who wanted to take it all back. So lacking any national federal army, the militias were very important. And the Second Amendment, in my view, referred to that. All right. That's why it talks about a well-regulated militia. And for some 200 years, it was thought that that Second Amendment did not give the right, did not give individuals a right to bear arms. And then in, oh no, 30 years ago, more or less, Justice Scalia wrote an opinion which for the first time recognized that there was an individual right to bear arms. But what he said in that opinion, which is still law, is that that right to bear arms applied to the right to own a handgun in one's home for self-protection. And then went on to say that doesn't mean that anybody can have the right to take any kind of weapon out in the streets for any reason. He just left that blank, okay? So here's another thing that needs to be interpreted. His opinion, which the court adopted. How far does this right, which he recognized, limited to handguns in the home for self-protection, how far does it extend? And that's an open question at the moment as far as the federal government is concerned. As far as the state government is concerned, I guess I could buy a nuclear bomb. I mean, you can have anything in Arizona. And people keep saying Second Amendment rights as if it applied to any kind of gun for any purpose. But so far as the Constitution is concerned, it's limited at this moment to a handgun in the home for self-protection. Now, there are cases out there that are coming up this year. One from New York, which has followed very strict rules as to guns. And one from New York as to whether you can take guns out of your home for target practice, loaded guns for target practice exercises and so forth. And I think that case is going to be argued this year yet.
Okay. I think the one you're referring to with Scalia was the Heller opinion or Heller case.
The Heller opinion was Scalia's opinion, yeah.
Okay, Phil Nicolai had a question. Phil, did you want to address your chat that you asked or no?
Yeah, my question to Judge Feldman is, unless the redistricting and voting issues are resolved, do you feel that our democracy can survive?
I'm happy to give you the answer. I'm extremely worried that it will not survive. The present situation, well, you know what's going on, all of you know what's going on in Arizona and in other states about limiting the ability to vote, restrictions on the ability to vote. There are even bills in a bill in the Arizona House to the effect that to eliminate early voting, which would be a disaster. So the problem is the Constitution does not spell out the restrictions on voting. Let me put it this way. Article 2 or Article 1 says that the choice of electors, well, let's go back a step even. Article 1 leaves the question of choosing electors, time, and Congress represent to the time, place, and manner of choosing to the states, quote, subject to the regulation of Congress, end quote. But it doesn't say what regulation. So the question is, will Congress pass a voting rights bill? Well, they did pass one when Lyndon Johnson was president. They passed a civil rights bill. And then 5 years ago, they did that under the 14th Amendment. The 14th Amendment, Section 2. 14th Amendment gives everybody the right to vote, and Section 2 permits the Congress to pass laws regulating that, okay? So Lyndon Johnson's administration and Congress passed the Voting Rights Bill. And it had two sections that are important. Section 5, which applied to any place which had under Jim Crow limited the right of people to vote. They could not make any changes to voting procedures without the prior consent of the Justice Department. And that worked really well, except it was ruined by an opinion from Justice Roberts 5-6 years ago that said, we don't need this anymore. That's not constitutional. It puts a burden on things because there's no more discrimination in voting. I don't know where he got that idea, but so Section 5 went down in ruins there. Section 2 of the Voting Rights Bill enabled Congress to pass laws that was a law that enabled the Justice Department to address problems like gerrymandering and fair and equal representation in voting. And it worked pretty well, except then the courts have eaten away at that to the point that just what it is that the Justice Department and the administration and the courts will do in order to put an end to gerrymandering and other kind of limitations on the right to vote. And the court has said, well, gerrymandering violates the Constitution, but we cannot think of any, this is the US Supreme Court, we cannot think of any remedy, so we're not doing anything about it. So that's where that is. And it'll stay there until and unless Congress passes a new voting rights provision that addresses gerrymandering. So and also addresses the other problems. And we're down to the question of filibusters, because in order to do that, you need to get not just the majority, but a supermajority of 60 votes, unless the party in power amends the rules, which they can do with only a majority. And then you have Senator Manchin and our good Senator Sinema, who are not committed to do that.
Right.
I don't know whether they're going to get committed or not. But unless things get fixed, I have a lot of concern that we will not have an open, fair election. And everything that you've been reading that's being done and contemplated to be done in order to limit the right to vote and to actually change the results of the election, that may well take place, and you will have a minority government, a very, very small minority authoritarian government. That's my fear.
Sanda has a question for you, a two-part question. Can a Supreme Court justice who at the time of their confirmation said they would follow precedent, and once they're seated, they fail to subscribe to that notion, can this be considered as perjury and thus have them removed?
The easy answer is no.
Wow.
You can't get rid of them as long as they're on, quote, good behavior, unless you want to impeach them, which, as you saw with the efforts to impeach President Trump, requires a 2/3 vote in Congress, in the Senate.
Has a Supreme Court justice ever been impeached? Seems like it has.
I think once.
Like, yeah.
I
Can't
think
remember
once.
why.
Yeah, I don't know if he was convicted. It goes way back to the early years of the Republic. One of the early people of the who was nominated to the Supreme Court came from the South, landed in Baltimore, made a talk to the opposing party, and said some things that were made the majority in Congress very unhappy. And I think he was impeached. I'm not sure he was convicted, but.
A second part of this is a different, completely different, I think. But as a follow-up, should Trump be found guilty for the January 6th insurrection And could his appointees be removed?
Okay, I'm glad, I don't know who asked that question, but I'm glad they asked it. Back to the 14th Amendment. Section 2 or 3 of the 14th Amendment was, in 14th Amendment, 13th, 14th, and 15th Amendments were passed right after the Civil War. And they were passed only because the states, it needed states in the South to ratify them in order to get a 2/3 or 3/4 majority of states. And at the time, these so-called Civil War amendments, the 13th said that everybody got a right to vote regardless of race. The 14th had equal protection, due process, and so forth. The 14th Amendment has a provision that was put in to make sure that those who had engaged in insurrection, meaning civil war, but the word they used is insurrection against the United States, were forever barred from ever holding any office in either the federal or state government, because the Congress at the time wanted to make sure that the people like Robert E. Lee and so forth, who had led the South in the Civil War, would not get themselves elected to a federal or state office. That provision is still there. So if Trump is guilty of insurrection, and the amendment uses the terms insurrections against the United States or giving aid or comfort thereto, if Trump is found guilty of insurrection, he cannot hold office, and the people who were engaged in insurrection with him or gave aid and comfort cannot hold federal or state office again. Now, I have written this is interesting for the state, I think. I have written the head of the Democratic Party of the state. We had 3 people, Representative Fincham in the House, Representative Gosar in the House, and Representative Biggs in the House of Representatives, who were present on the 6th of January and were in the crowd. So were they guilty of insurrection or guilty of aiding and giving comfort to those who were guilty of insurrection? If so, they should be disqualified from holding office. So I don't know what the party's going to do about it.
Could Trump telling people that they should fight like hell and march upon the Capitol, and he was going to go with them and so forth, is that inciting or is that just a suggestion?
Well, he says it's a suggestion. I think it was inciting. I think it was just clever wording and to get them to do what they did.
Right.
And I think even worse is he spent hours watching it on TV and being asked and begged to get back on TV and tell him not to do this anymore. And he wouldn't pay attention. I think it was 3 hours before he told them, go home. We love you. We understand you. Go home. So I think that you could persuade a jury that he was giving aid and comfort, or inciting it to begin with and giving aid and comfort thereafter.
Right. Well, it depends on that jury, doesn't it?
Yeah, a lot of things do.
Yeah. So here's another question for you. Another comment. The only justice to be impeached was Associate Justice Samuel Chase.
Yeah.
In 1805, the House of Representatives passed articles of impeachment against him. However, he was acquitted by the Senate.
Yeah. Yeah, he's the guy I'm talking about. I didn't remember his name. And it's an interesting historical story. The reason he was impeached is making this speech, which displeased the majority in the House of Representatives. So they impeached him. I think it was him. Okay.
Mike and Lois Norman, turn on your video so we can see you. Okay.
Hi, yeah, a question. You've been in the political judicial arena for some time. I'm sure you've seen a lot of changes. My question is, why is the political discourse these days so adversarial? And do you think there's any hope it will change?
Well, why is it so divisive? Well, I think that the division is natural in any democracy. There are different views. People have different views. So divisiveness is to be expected in a democracy. But what's going on now is not just differences of opinion. I mean, it's not just bitter, it's hateful, it's threatening. It's to the point where people wouldn't want to run for office because they're exposing their families to death threats and themselves to death threats. The governor of Michigan, God bless her, you know, she was, they almost kidnapped her. They almost succeeded. She goes around with bodyguards now, super bodyguards all the time, and her family does. I think all this got started with Newt Gingrich some years ago, who made a point of not just I don't agree with you, but if I don't agree with you, you're not just wrong, you're bad. You don't understand. There's something wrong with you. And it's gotten worse. And then Trump comes along, and he, I think, has really opened the floodgates to this terrible divisiveness that is based on hatred, by the idea that I don't want to even consider what you've got to say. If you don't agree with me, you're a bad person, you're a traitor, you're a communist, you're a socialist, you're this, you're that. And to the point where people in Congress talk about hanging their opponents. I mean, that's how bad it's gotten. And I don't know how to fix it. President Biden is trying to fix it, I think, by being, by not engaging in name calling, by talking about unity, but I don't know how you can have any unity with people who refuse to see the thing that's just before their eyes. I mean, people in Congress and people running for office and so forth who look at what happened January 6th, which is on film. I mean, we know what happened, and they see it as a bunch of tourists going through the Capitol. How do you talk sense to people like that? To the QAnon people, the people who say that Hillary Clinton is running a sex ring out of the basement of the pizza parlor in Washington, D.C. I don't know how you talk those sense to people like that. You know, I used to try lawsuits, quite a few of them. And I always thought that the way you talk to juries is with common sense and good sense. But I don't know what you talk, what will convince, or how you can even begin to have a dialogue with some of these people on the extreme right.
I think I saw something on PBS the other day, it might have been PBS, or about the Russian KGB methodology is to divide and use misinformation to destroy an economy, or not an economy, but a democracy or an enemy. And that's their methodology, which we may have been seeing for the past few years. What do you think?
I think we have been seeing it the last few years. You know, when I went to law school, and in the years later practicing, so forth, but one of the things you absorbed in law school by the person who taught First Amendment law is that the solution and the remedy for improper speech or incorrect speech was correct speech, that would finally prevail. And I think for a long time that was the case, but I'm not sure now, because the ability to disseminate the craziest ideas over all these platforms is so great, and there are no gatekeepers anymore. There used to be, you know, we had great newspapers, great magazines and all. There used to be editors and gatekeepers who kept out some of the worst things. But now, hey, if you think the earth is flat, you can go on the internet and convince heaven knows how many people.
I have great trouble understanding the reluctance of Merrick Garland, our Attorney General, to prosecute aggressors in the January 6th, or those who promoted the aggression on January 6th. It's hard for me to understand why he has yet to act on the criminal referral of what is his name?
Well, you think he's going too slow?
I think he's doing nothing. He's going after the very low people that took part in the insurrection with very little sentences. I have trouble to watch Steve Bannon purchasing a house in Oro Valley for over $1 million, being allowed to continue his propaganda and spew hatred while he's awaiting criminal trial. I have Mark Meadows has been referred for criminal and nothing has happened. It's 3 months at least since he was referred to Mark Meadows, not to mention that he's doing nothing for Trump. So I felt also the difference between Merrick Garland protecting the bad people and Bill Barr who protected Trump for the time that he was in office. Can you explain Merrick Garland to me and why is this happening?
Merrick Garland is a man of great principle and one who adheres to the democratic traditions, especially in the prosecution of crime. And his goal was, his vow was, and his instructions from the president was to restore the Justice Department to its traditional ways of going at things. Now, I happen to agree with you. I think he's going too slow. But I understand also the difficulty of criticizing because I know how the Justice Department works on cases like this. They try and get, that's why the verdict I mentioned this week or last week of this one person, Refit, I guess was his name, was so important. They try and get the smaller fish before they get the bigger fish. Because now that they got one conviction, and I hope a very long sentence for this guy, Refit, then the others that are waiting for trial are going to have to start worrying, gee, we may get convicted. We may get a harsh sentence. Maybe we ought to cooperate with the government and we ought to tell the government what we know and testify against the others. And to some extent that happened in the Refit trial. But that's how the Justice Department has always gone against these big cases, trying to get the little fish, to turn them, to get them to testify against the big fish. So I think he's going a little too slow, but I can't criticize too much because I know how they usually work and I know how careful they are about not wanting to bring charges unless they feel they really have a tight case that they have a very good chance of winning. But I think they ought to take a little more chance. It's important to get these cases to trial, but also if they lose them, if they start losing cases, then they're going to have a lot of trouble getting people to turn. And then, of course, along comes Trump and says, you know, trying to get people not to turn and testify against the right-wingers. Trump says, I'm going to pardon you all when I get reelected. So there are those problems, but I do think he's going a little too slow. I wish they were going a little faster against Trump. One thing I really dislike is these letters, these efforts like to talk to Ivanka Trump and to the Trump kids and so forth, send out a letter saying, we want to talk to you and have a negotiation about whether or not you'll testify. And, you know, when you're dealing with hostile witnesses, the rule has always been, when I was practicing law, the rule has always been that subpoena them, subpoena the documents, and tell them that they've got to appear at a certain place at a certain date to answer questions. You don't have to tell them just what you're going to ask, just appear and answer questions. And then send a nice letter. If it's inconvenient on this and that date, let us know and we'll try and work with you. But these negotiations about whether you're going to come, I don't know, it takes too long. I hope you can hear me over. There's a siren out in the street behind me. So I hope that answered your question.
That answers my question. But
Okay,
it doesn't explain why Steve Bannon was not carted to jail and was allowed to go home and continue his podcasting, making money and spewing.
Well, I don't think he's charged with a crime yet.
But I mean, when a person is awaiting trial, don't you put them in jail to await trial? Why do you send them at his luxurious home?
Well, I'm not sure I understood what you were saying, but if he's not charged with a crime, not yet charged with a crime, he can do anything I can do, anything you can do.
does he have a trial in May?
Well, then he's on bail. Has he been charged?
I think so.
Well, if he's charged and he's out on bail, he can still do what he wants, subject to any rules and restrictions by the court. But I don't know that he's been charged. I could be wrong.
Something that we can look at.
I think what they're still doing is he's under subpoena.
I have a question for you, Justice. Trump seems to be able to delay things forever. Well, he was associated with Roy Cohn, and Roy Cohn's message was to deny and delay
Mhm.
and sue. How does that work, given your point of view and your experience? You've seen it happen. So how does it happen? How can they continue on forever and ever and ever and never get to a
Well,
resolution?
to some extent, it's the fault of the system. It's designed to give the maximum protection to those accused of crime or those accused of civil wrongs. And we have terrible problems that way. And to an extent, it's the design of the system. To an extent, it's the failure of judges to really put the clamps on some of this nonsense. They want to appear neutral. I think Christian Amanpour, the great journalist, when she was in Tucson a few years ago making a talk, and she talked about the requirements of good journalism, which, as she put it, were to be objective, not neutral. And I think we need a little more of that from the judicial system too. You know, it's always been the case. If you've got power, if you've got money, got lots of money, and the more money you've got, the more you can fight.
Tell us. Oh, Pat Sharp has a question. Go ahead, Pat.
Just two things. Welcome, Judge Feldman. Thank you for coming so much. Two of the attorneys in New York resigned because when somebody came in and took over that department, he didn't want to follow through on a case that they had worked on so hard. When I first read that, I thought that they were that something was wrong with them. But when I read further, they were just disappointed that they couldn't continue on that case. Did you read about that?
I did. What happened as I read it was that they wanted charges against Trump to be filed for fraud, essentially, having to do with his financial dealings and his submission of fraudulent, what they considered to be fraudulent financial statements to lenders. And the previous county attorney or district attorney in New York City had more or less agreed with them. But he resigned. So a new one came in, and the new one didn't agree. And the new one said, well, try and convince me. And so they appeared and they argued the case to him. And then he said, you're not convincing me. I will get a panel of people from the department, see if you can convince them. And the two people could not. And I think it had to do, as I read it, and I forget, I read all sorts of magazines. And so I think it had to do with the fact that although the statements were fraudulent, no fraud had been committed because the lenders did not rely on the statements.
Oh,
That I gathered was what it was about. And these two guys that had wanted to prosecute, they were upset that the department wouldn't do it, and so they quit. And one of them, I think, said he'd come back if anybody changed their mind.
oh, well, that's interesting. Yeah, that
so
was.
that's about all I know of it.
I think you explained it well. The other thing I wanted to ask you was something I read on the internet just yesterday or today about the fact that the voters of Arizona voted in a tax on high wage earners to supplement the budget for the schools.
Proposition 208.
And that has now been knocked down by the courts.
Yeah.
What I read was with the Maricopa Supreme Court, Superior Court, who was following, I guess, what had occurred in the Arizona Supreme Court, was that would make the budget too high for the schools. And I mean, if the voters want that, it just
Yeah.
seemed like it was being torn down by some kind of technicality.
Well, it wasn't a technicality. Uh, Don't blame the Maricopa County Superior Court judge, who I knew his parents, who both have passed away, and I know him. He happens to be A1, and his opinion, which I have read, said, I'm doing this because I have to do it, but I don't like it. He didn't put it in those words. And he more or less said something that Superior Court judges never say about Supreme Court. He more or less said that this Supreme Court has written a terrible opinion that makes me do this, even though it's not right, and even though it's political, but I have no choice, so I'm going to do it. Now I'm paraphrasing, okay? He put it much more tactfully than that, but it's not his fault. The problem is that Proposition 208, which lays this tax, was passed, but years before, maybe 10 or 12 years, another initiative had been passed which laid a cap on the amount that school districts could spend on their local districts. And the Arizona Supreme Court, when 208 got passed, and the chambers of commerce and the Republicans in the legislature and everybody wanted to find some way to get rid of 208, went to the Arizona Supreme Court and said, you've got to enjoin the collection of the tax under 208. You've got to enjoin it because there's no sense in collecting the tax because it can't be spent because of that 10 or 12-year-old cap on spending. And the Arizona Supreme Court said, that's right, and we'll send it back to Judge Hanna in Superior Court, and he can let us know if there's any way out of doing that. And he said he couldn't find any way out. And I'm on the board of the Arizona Center for Law and the Public Interest that handled the case for 208. And I'm waiting to hear whether they're going to try and go back to the Supreme Court. I don't know if they are or not. Does that?
Here's some information about Steve Bannon. Phil Nicolai sent this. Steve Bannon was charged with criminal contempt of Congress, November 12th, 2021.
Oh, okay.
Federal prosecutors charged him over his defiance of a subpoena from the Congressional Committee investigating January 6th. So
criminal contempt of Congress is a lot different than being charged with a specific crime.
Oh, really?
Yeah.
Okay. Well, I used to think that if you were subpoenaed, you just automatically had to go show up. Obviously, people are ignoring that. How can they do it?
Oh, they're claiming that the subpoenas are designed to require testimony about the relationship between the person subpoenaed and the president, and that there's therefore a privilege.
Executive privilege.
Yeah, like attorney-client privilege, like doctor-patient privilege. And I think that is a ridiculous contention. There's nothing in the Constitution about privilege, the word, except privileges and immunities of citizens, nothing to do with attorney-client privilege or presidential privilege. The courts have recognized some degree of privilege of communications between the president and his advisors that have to do with the making of policy and things like that. But there's no privilege that entitles you to ignore a subpoena, nor to ignore having to testify about things that have nothing to do with advising the president with regard to policy. Nor is there a privilege that prevents you from coming. You can come and say, I'm not going to testify to so-and-so because it's privileged, but you're sitting your body down in the chair saying, yes, I'm Steve Bannon or Joe Blow, and I'm claiming the Fifth Amendment, or I'm this or that. So I think this whole thing is ridiculous, and I'm hoping that the courts will throw it out. And so far, as it goes through the lower courts, nobody has recognized the privilege. But of course, we go back to going back over court to court, armies of lawyers. I
Right.
hope that answers your question.
Yeah, well, for a good dose of hypocrisy, Donald Trump once said, those who don't testify or use the fifth are guilty.
Yeah,
It's changed, hasn't it? From his
sure.
word
Everything changes depending what he needs at the moment.
at the moment. Right, right.
Yeah.
So, okay, does anyone else have a question? I'm sure there are millions. Maybe the last thing I'll have you do, if nobody else has a question for now, you want to address some of the things that the Supreme Court is taking on now, like voting issues, the abortion issues, etc.
Well, there's the gun issue I mentioned, the extent to which Justice Scalia's opinion will be extended to rights other than a gun in your home for self-protection. There's the abortion issue. Texas and Arizona and I think Mississippi or Alabama are trying to reduce the right to have an abortion so that it has to be claimed within the first 15 weeks, which of course is contrary to Roe versus Wade and the Casey case. And so it's out and out a violation of the Constitution as it has been interpreted. See, and this is another example. There's nothing in the Constitution about abortion, of course. So how did we get a constitutional right to abortion? Well, it started out, I'll go through this because it's an example of how things get interpreted case by, there's a case called Griswold versus Connecticut from, I don't know, 40 or 45 years ago, involving the statute in the state of Connecticut, passed by the Connecticut legislature, that made the selling of condoms a crime. And they the case got to the US Supreme Court, and the plaintiff says that the statute making selling a condom a crime, or using or buying a condom a crime, violates the Constitution. Well, what constitutional right does it violate? Well, the court at that time, this was the Warren Court, the court at that time said, well, there is a penumbra of rights, those not expressly stated in the Constitution, and one of them is the right to privacy, the right to privacy in your bedroom, and with regard to your sex life. So the statute outlawing the sale of condoms is unconstitutional. Griswold led to Roe versus Wade. Okay, so Roe versus Wade is on the agenda for argument. Several of Justice Thomas and several of the others believe that it was wrong, that Roe versus Wade was wrongly decided. I don't know what they think about Griswold versus Connecticut, and they want to overthrow it completely. And this 15-month 15-week provision, maybe they can get it reduced to that, or maybe they can get it overthrown completely. So that's the that case is there. And then of course there are cases involving restrictions on the right to vote under Section 2 of the Voting Rights Act. And so all those cases are before the court. And then of course there is the nomination of the new justice appointed by President Biden.
That's right. That's right. And what do you think is going to happen there with that confirmation?
Well, I think the Republicans will avoid saying that we're opposed because she's Black. And I think what they will say, we're opposed because she's too liberal.
Mm-hmm.
and she's not really that liberal from what I've read of her record. I don't know her, but she's not really that liberal. She's a pretty moderate. If she's liberal, but pretty moderate about it, all right? And she seems to have a world of experience and is very well qualified. But I think that's what they'll do. But you don't need the filibuster rule. You know, filibuster is just a Senate rule, not a constitutional provision. The filibuster rule does not apply to the nomination and approval of a Supreme Court justice. So the Democrats can do it with no Republican votes, providing they get Sinema and Manchin to go along. And maybe they'll get a couple of Republicans to go along, because there were a few of them that voted in her favor when she got appointed to the DC Court of Appeals, I don't know, 3 years ago, I think.
Yeah, when she was being interviewed for that, I think they were relatively positive about her.
Yeah.
But this is a different
Yeah.
situation. So Claudia Levin has a question for you.
Okay.
I was wondering, I've been hearing about the fact that a lot of states have finally approved the ERA, and whether or not that's actually going to become a part of the Constitution or not. And if it does, wouldn't that supersede some of these restrictive reproductive rights issues?
Would you ask that again? Because I didn't get the first part.
Oh, the ERA?
Equal Rights Amendment?
Yes, and it's supposed to be enrolled by the archives or whoever does that. And I don't know if it has been or not, because the number of states required to pass it did eventually happen.
It has not been passed yet.
Yes, but there's some controversy about whether it's going to become actually part of the Constitution. But if it does, would that not have an effect on some of these reproductive issues?
It's hard to say. It might. You could make the argument that it would, but it's very hard to. One of the faults, one of the problems with the Constitution is the difficulty of amending it. In order to amend it, you've got to get 2/3 vote of Congress. I don't know how you get anything through Congress nowadays with a 2/3 vote. You need 2/3 vote of Congress and a vote of 3/4 of the states. So that's equally difficult. And something as controversial, we're into the culture wars again. The argument against approving the Equal Rights Amendment is that it'll allow women to have rights like, just what you mentioned. One of the problems with the right-wing people is that, well, then they're going to argue that the liberals will argue that the Equal Rights Amendment protects the right to an abortion and protects the right to this and protects the right to that. So I don't know if it's going to get passed. It needs, I don't know how many more states it needs, but these things are very hard to pass. The reason you plan to vote in the next election, and the reason you can for federal office, is the 19th Amendment, which was passed in 1919, I think. 19th Amendment gave women the right to vote, or more accurately, prohibited states from denying women the right to vote. All right. That amendment, which you would think was a product of, almost 100 years, since 1848 to 1919, of women rallying for the right to vote, protesting, and so forth. That 19th Amendment passed by one state, Tennessee, in 1919, and it was a terrible fight there. And it passed in Tennessee by, I think, only 2 votes in the state legislature. So these things are when you get into the culture wars, these things really are difficult. I don't know if the Equal Rights Amendment's going to pass or not.
Well, it supposedly did, because the 38th state or whatever it was of Virginia, I think it was, did finally pass it, but it's been like 50 years and I don't know. And then somebody said, well, it doesn't count because it was too long and this and that. But a lot of people are saying that it has gotten the right number of states, and that it should become a part of the Constitution, the 28th Amendment.
Well, I think what happened is, and I'm not certain of this, but I think that Virginia did pass it, and it may be the last state, but it had a time limit for passage. And the passage in Virginia exceeded the time limit. I think that's the situation.
We're arguing
I
about.
don't know. So then it'll be up to the Supreme Court to decide if that's the situation, be up to the Supreme Court to decide on whether the time limit applied or not. And I don't know what the arguments are about that.
And if I'm not mistaken, I think the 1919 amendment was only white women could vote. I don't think blacks or.
No,
Native
no, they
Americans.
couldn't. Well, they couldn't do that because the 15th Amendment, 15th Amendment to the Constitution, the last of the Civil War amendments, prohibited excluding the right to vote on grounds of race.
Mhm. Okay, I think we're almost done because of time, but could you tell us something that this is something I found when I was reading about you about the bars, the liability of bars and alcohol? That's something you were involved with, weren't you?
Oh, how did you connect me with that?
I don't know. I was reading something about you in an article about you from a few years ago.
Well, I wrote one of the proudest things one of the things I'm most proud of when I was on the court. I wrote the opinion that reversed previous cases that said and held that the owner of a bar, of a saloon, any place that served a licensed person that had a license to serve liquor could be held liable civilly for over serving a customer when that customer left the bar, got in his car, drove and injured somebody in an accident. And I wrote that opinion. Up till that date, they could serve as much as they wanted. The bar owners didn't care. They didn't, and things had changed since that opinion, to the point where they now give owners of bars are required by their insurance companies to give lessons to their bartenders and waitresses and waiters to recognize when the customer is getting overserved and what to do about it. And we have, my wife Norma is here. She won't go on Zoom, but our grandson was running a bar, a high-end luxury place. And he called me up one day and he said, "Grandpa," he said, "we got a real problem." I said, "What is it, Brian?" He said, "Well, I got a doctor here who's had too much to drink. And I've taken her keys away from her. And so she can't drive because she's going to hit somebody sure as can be." And he said, and she insists that she's going to sue me because she wants her keys so she can get in her car. And I don't know what to do. And I said, "Tell her you're going to give her her keys in 10 minutes. And in the meantime, you're going to call the sheriff and have a car in the parking lot so that the minute she gets in, they can arrest her and starts her motor. They can arrest her for drunk driving." So that's just an example of the kind of thing this accomplished. And I'm proud of that because I think that opinion has saved a lot of lives, an awful lot of lives.
That's good. What year was that? Do you remember?
I think it was in the 1990s.
90s? So 30 years. Wow. Okay, there are two really quick chats I want to read, and then we have to stop. Phil Nicolai said, "Isn't the abortion issue really a woman's rights issue?" And then the next one, he said, "Some states have passed legislation withdrawing their approval for the ERA." Those two things he mentioned. And then there is one more thing, that this has been wonderful with much information. Thank you for taking the time to speak with us.
Well, thank you for having me. My pleasure. And I have one thing more to say. This election coming out is going to be one of the most important elections we have ever had in the history of this country. And it's not enough for everybody just to vote. Everybody's got to vote and take their family out to vote, take their friends out to vote, that every vote's going to count. And it's not going to be easy. No matter how things work out, there's going to be a lot of impediments in place to voting, but everybody's got to vote,
For this 2022 especially.
Yeah.
And then
Yeah.
24 is going to be a nightmare too.
Yeah,
So,
but it's important for Congress in 2022,
oh yeah,
keep it out
for
of
sure.
Republican hands.
And traditionally, the House loses members, 15,
Yes.
20,
Yes,
almost every year, every
Yeah.
time, I mean.
yeah,
Okay, well, thank you so much for being with us. You've been a wealth of information. We'd love to have you back if at all.
All right.
However, and maybe after the election, we could do that, huh?
Oh, okay, be glad to.
Okay, I do have to make an announcement, and that would be during the month of March, we are collecting adult and children flip-flops for Casa Alitas. Bring those to the headquarters Monday, Wednesday, and Friday, 10 till 2. Flip-flops during the month of March. And I think that is it. And thanks for everybody for being here.